The 7 steps of filing a Toledo injury lawsuit. If you've been injured and you're wondering whether you have legal options, you're not alone. After an accident, it's completely normal to feel overwhelmed, confused, or unsure of what to do next. That's where understanding the process can make a real difference. At Zoll Kranz, we're a Toledo injury law firm dedicated to helping injured people understand their rights and take informed next steps. We know that filing a Toledo injury lawsuit can sound intimidating, but in reality, the process follows a clear set of steps, and you don't have to navigate it on your own. In this video, we're going to walk you through the key steps of filing a Toledo injury lawsuit using plain language and real-world explanations so you know what to expect and how the process works from start to finish. If you'd like to talk to someone about your situation, Zoll Kranz offers free, no-obligation legal consultations. You can call our team directly or visit toledolaw.com, where you can use our secure chatbot to share information about your case and potentially find out right away whether you qualify. Let's start by looking at the first step in any Toledo injury lawsuit. Step 1. Getting medical care and protecting your health. The first and most important step after any injury is getting medical care. Your health and safety always come first. Even if your injuries don't seem serious at first, it's important to be evaluated by a medical professional as soon as possible. Many significant injuries, like soft tissue damage, internal injuries, or head trauma, aren't always immediately apparent and can worsen over time if left untreated. Getting prompt medical treatment not only protects your health, it also creates important documentation. Medical records clearly show when you were injured, what injuries you suffered, and how those injuries have affected your daily life. This documentation plays a critical role in a lawsuit because it helps connect your injuries directly to the accident or incident that caused them. Insurance companies and opposing parties often review medical records closely. If there are delays in treatment or gaps in care, they may try to argue that your injuries weren't serious or weren't caused by the incident at all. Seeking medical attention right away helps avoid those issues and ensures there is a clear, accurate record of your injuries from the start. Simply put, taking care of your health is the foundation of any lawsuit, and it's the first step toward protecting both your well-being and your legal rights. Step 2. Talking to a Toledo injury lawyer. After getting medical care, the next important step is talking to a Toledo injury lawyer. A consultation with an injury lawyer is confidential, pressure-free, and designed to give you clarity, not push you into a decision. It's simply an opportunity to explain what happened, ask questions, and understand what your options are. It's especially important to speak with a lawyer before talking to insurance adjusters or other parties involved in the incident. Insurance companies often reach out quickly, sometimes within days of an accident, and they may sound helpful or concerned, but their primary goal is to protect their own interests, not yours. Statements made to insurance adjusters can be recorded, taken out of context, or used later to minimize or deny a claim. Even something that seems harmless can impact a Toledo injury lawsuit if it's misunderstood or misrepresented. An experienced injury lawyer knows how to handle these communications and can speak on your behalf, helping to protect your rights from the very beginning. By talking to a Toledo injury lawyer early in the process, you give yourself the best chance to avoid common pitfalls, understand your options, and make informed decisions about how to move forward. Step 3. Investigating the injury and determining liability. Once you've spoken with a lawyer, the next step is investigating what happened and determining who may be legally responsible for your injuries. This is something your lawyer handles for you. Determining liability isn't always straightforward. and it often requires a full review of the facts, evidence, and circumstances surrounding the incident. For that reason, it's important not to admit fault or take responsibility on your own, even casually or out of politeness. You are not expected to be a legal expert, and you may not have all the information needed to determine who was truly at fault. Admitting fault too early can negatively impact your claim, especially in cases where liability may be shared or disputed. Statements made at the scene, to insurance companies, or to other parties can be used later to reduce or deny compensation. Your lawyer will conduct a thorough investigation using evidence such as accident reports, medical records, photographs, video footage, witness statements, other evidence. They may also work with professionals who can help reconstruct what happened or explain how the injuries occurred. This process helps build a clear, accurate picture of responsibility based on facts, not assumptions. By allowing your lawyer to handle the investigation and liability analysis, you protect your claim and ensure that your Toledo injury lawsuit is built on solid, well-documented evidence. Step 4. Filing the Toledo injury lawsuit. Filing a Toledo injury lawsuit simply means formally starting the legal process. It's a legal step that notifies the responsible parties that you are seeking compensation for your injuries and losses. This step is not aggressive, and it doesn't mean you're escalating a conflict. Filing a lawsuit is often necessary to preserve your rights, meet legal deadlines, and allow your lawyer to continue advocating for you within the legal system. It's also important to understand that filing a lawsuit does not automatically mean your case will go to trial. Many cases continue to be resolved through negotiation or settlement after a lawsuit is filed. Filing simply keeps all options open and ensures your case can move forward if needed. Step 5. Insurance companies and negotiations. Once a lawsuit is filed, insurance companies typically become more involved. They review the claim, assess the evidence, and decide how they want to respond. Settlement negotiations are simply discussions about resolving the case without going to trial. During these conversations, insurance companies may make offers to try to close the case for less than its full value. While these offers can sound reasonable at first, they don't always account for the long-term impact of your injuries. Your lawyer's role is to handle these negotiations for you. They understand how insurance companies operate and work to protect your interests, ensuring any settlement discussions are based on the full scope of your injuries, losses, and future needs within your lawsuit. Your lawyer will keep you informed throughout the process, presenting any settlement offers with you and providing you an opportunity to accept the terms along with their own analysis of the offer. Step 6. Discovery and case preparation. During a lawsuit, both sides may exchange information in a process called discovery. This simply means sharing relevant details, documents, and evidence so each side understands the facts of the case. At the same time, your lawyer continues preparing your case by organizing records, reviewing evidence, and strengthening the legal arguments that support your claim. This preparation does not require you to navigate legal procedures on your own. Your attorney handles the process and guides you every step of the way. It's important to know that discovery and case preparation can happen at the same time as settlement negotiations. While discussions about resolution may be ongoing, your lawyer is still actively building your case to ensure you're in the strongest position possible throughout the process. Step 7. Resolution. Settlement or trial. Every lawsuit ends in one of two ways: a settlement or a trial verdict. A settlement occurs when the case is resolved through an agreement, and this can happen at almost any point in the process. Many injury lawsuits are resolved this way, often without the need to go to court. A settlement allows the injured person to receive compensation without the uncertainty of a trial. A verdict, on the other hand, can only come through a trial. This happens when the case cannot be resolved through negotiation and a judge or jury is asked to decide the outcome. While not every case goes to trial, having a case prepared for trial can play an important role in achieving a fair result. Ultimately, the goal of an injury lawsuit, whether resolved by settlement or trial, is fairness, accountability, and compensation for the harm you've suffered. If you're dealing with an injury, it's important to know that the Toledo injury lawsuit process doesn't have to feel overwhelming. With the right guidance, each step is manageable, and you don't have to figure any of it out on your own. At Zoll Kranz, we're here to advocate for injured people throughout Toledo. Our role is to protect your rights, handle the legal complexities, and help you pursue fair compensation while you focus on your recovery. If you have questions about your situation, Zoll Kranz offers free, no-obligation legal consultations. You can call our team directly or visit toledolaw.com to get started. On our website, you can use our secure chatbot to share details about your case and potentially learn right away whether you qualify for a Toledo injury lawsuit. Taking the first step doesn't commit you to anything, it simply gives you information and clarity, and that can make all the difference.